Ready? Start. After giving our careful consideration to the facts and circumstances of the case and the submissions made by the learned counsel for the parties, it appears to us that it is quite evident from the scheme of various subsections of Section 25 of the Act that whenever an application for closure of an industrial unit is made by an employer, the state government before whom such application is made is required to dispose of such application within 60 days from the date of making the application and communicate its decision within the said period of 60 days so that an employer does not suffer any hardship on account of failure on the part of the state government to dispose of such application for permission of closure expeditiously. Stop para. In order to impel the state government to dispose of such application expeditiously, not exceeding 60 days, provision has been made that if the decision of the state government on the application for permission to close an industrial unit is not communicated within the said period of 60 days, it will be deemed that such permission has been granted. Stop. Since the decision on the application for permission for closure is to be taken by the executive authority, namely the state government, and since no provision for statutory review before other authority has been made, the legislature has incorporated the provision of review by the state government of its decision on the application for closure either on its own motion or on the basis of the application to be made by the aggrieved party. Stop. As the decision made by the state government on the question of closure of an industrial unit cannot bring about serious consequence affecting productivity, employment opportunities, etc. The decision taken on the application for closure has been made operative for 1 year only, so that after such period, if an employer still desires that the industrial unit should be closed, it may make a fresh application for permission to close the said unit. Stop. It is quite obvious that in such application not only the factors which were indicated in the previous application in justification of closure of the industrial unit, but other factors emerging with the passage of time may be placed before the state government for taking decision on the application for permission to close. Stop. Para. In order to evade any unmerited hardship meted out to an aggrieved party on account of improper and or incorrect decision made by the state government on the application for permission to close, even during the period of 1 year when the decision of the state government remains operative, the review application may be made by the party aggrieved. Stop. Even apart from such application, the state government may also initiate suo motu proceeding to review its decision. Stop. If the state government passes any order on such review application, such order will supersede the initial order made on the application for permission to close. Stop.